They sure do like wasting taxpayer dollars, don't they? Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we have a decision. Judge has made a decision on the defense team's jury bias change of venue survey, and we are going to go over the documents. Not only do we have a decision, but we also have a date set for the change of venue hearing. Let's just go ahead and get straight to the document. And just like that, right off the bat, you guys already know what's going on here. As titled, Order Allowing Defense Surveys to Continue. On March 22nd, 2024, the state filed a sealed motion for order prohibiting further contact with prospective jurors absent leave of court. The same day, defendant Bryan Kohberger filed an objection to the state's motion with the promise of a forthcoming affidavit and memorandum in support of the objection. The court then entered a temporary order prohibiting both parties from contacting potential jurors about this case, including via third parties, until further order of this court. A hearing on this issue was set for April 4th. Yes, it has been an interesting 2 past hearings, hasn't it? In the interim, the defense filed a memorandum in support of objection to the state's motion for order prohibiting contact with prospective jurors absent leave of court. Look, guys, I'm just going to let you guys know right now, I'm probably not going to read every little bitty title because it's quite a bit and we know the back and forths. Okay. Basically, I'm just going to skim with my eyeballs right here. This is just, they filed this, then they filed this, and then the defense filed this, and then the state filed this, and then we had a declaration from Bryan Edelman, which is the survey man, and all of this stuff went back and forth. That's all this says right here. The April 4th, 2024 hearing was open to the public because neither party requested that the hearing be sealed. Keep that in mind. At that time, the court heard arguments from both parties regarding a survey the defense has conducted in Latah County and wished to conduct in 2 additional counties. The state took issue with 9 of the questions in the survey, which were read into the record in open court, and argued that asking those specific survey questions to potential jurors violated the court's revised amended non-dissemination order entered on June 23rd of 2023, also known as the gag order. Specifically, the gag order prevents the attorneys in this case or their agents from making out-of-court statements which a reasonable person would expect to be disseminated by means of public communication and that relate to the following: the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. And 2, any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. The state asserted that questions violated these provisions because the surveyors are agents of the defense, and the defense bears the responsibility to honor the non-dissemination order. Now, when it comes to this, we do know from the hearings, well, it was a little bit muddled in the first one, let's not forget that. But in the second one, it basically got clarified to us that there was an email sent over to Dr. Edelman, who was the doctor who worked on the survey, about the gag order. The defense argued that the questions in the survey were based on information obtained by defense expert Bryan Edelman from reading and watching various news articles and broadcasts from both mainstream media and social media. The defense further argued that the questions did not violate the gag order because they constituted information contained in the public record. The defense argued that the public record encompasses all information in the media for the public's consumption. I agree. The gag order expressly allows attorneys involved in the case and their agents to make extrajudicial statements, written or oral, concerning information contained in the public record, meaning that if it's in the public record, they can talk about it. That's what the gag order says. The gag order says if it is public record, if it is information that comes from the public record, then you can talk about it. And let's just be quite honest here. Every little bitty thing that is public record when it comes to the criminal complaint, when it comes to the exhibits for the PCA, when it comes to all of the search warrants, all of those things are public record. All of them. So with all of those social media search warrants and the phone record search warrants and everything that's in the PCA when it comes to, oh, he was over there 12 times and all this crazy stuff, the questions were very well put together if you consider all the actual information out there, okay? At the conclusion of the hearing, the court ruled that defendants' due process rights had not been violated because the order to pause the surveys was entered after a defendant filed an objection to such order. And 2, the order was temporary, and defendant was given notice and the opportunity to be heard at the hearing set shortly after the temporary order was filed. I agree. I agree with that. The Due Process Clause of the 14th Amendment to the United States Constitution provides that no state shall deprive any person of life, liberty, or property without due process of law. The right to procedural due process guaranteed under both the Idaho and United States Constitutions requires that a person involved in the judicial process be given meaningful notice and a meaningful opportunity to be heard. Due process requires that judicial proceedings be fundamentally fair. Procedural due process is not a rigid concept, but rather it is flexible and calls for such procedural protections as the particular situation demands. That's interesting too, though, that it's not just like clear cut, that like circumstances can change. It's flexible, it's malleable. Yeah, that's nice to know anyway. Okay. The court also kept the temporary order prohibiting contact with potential jurors in place and instructed defense counsel to consult with Bryan Edelman to determine if there was a way the survey could continue while eliminating the concerning questions the state raised. The hearing was scheduled to continue on April 10th of 24, and oh boy, did it. Again, neither party requested that the hearing be sealed. Very good point, and keep it in mind a second time. The questions at issue were again discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumors in the media and on social media, while other questions were formulated based on information from the public probable cause affidavit filed by the state. So again, we have Judge, he said it in court. Okay, it's in the transcript for the court records, both of them that we had this hearing on, that now the judge is now putting in his own documentation fake news, false statements, rumors, not facts. And again, I asked the question, how does Judge know that? Like, I know he has seen some of the IGG, and he is also the one who determined which parts of the IGG got given to the defense, which I have a problem with because that means that at this point, the judge sitting on this case has more information than he should and more information about the situation than the defense team has because he has seen things that he is now not allowing the defense to see. So when it comes to the judge is sitting there listening to both sides, right? So if he's supposed to be getting pieces of information from both sides as this goes, then how is he able to stand there and be like, oh, that's not true? Oh, that's a false statement. I have serious questions about that. This is not the first time I've brought this up. I have questions as to how Judge can sit there and state out of his own face that these things are false. Because to me, he's not supposed to either be able to say stuff like that or he's not supposed to know that. Like, isn't he not supposed to know the truth till trial? That confuses me. After a lengthy hearing, the parties remained at odds over whether the 9 questions at issue should be allowed to be asked in surveys conducted by the defense in other counties. The court now orders the following. The public record, as that term is used in the non-dissemination order, means the public record of court, i.e., information from public hearings and from documents filed in the case that are not sealed. Exactly, like exhibits for the probable cause and all of the plethora of search warrants that are out there, right? Information that formed the basis for 6 of the 9 questions at issue came from the probable cause affidavit, a document filed in this case that is not sealed. The non-dissemination order expressly allows attorneys involved in the case and their agents to make extrajudicial statements. I can never say that word right. Oh my gosh. Written or oral concerning information contained in the public record. Additionally, one of the questions was not based on admissible or admissible evidence, but instead asked about the feelings of members of Moscow community. That must be about the fearful one, like were they in fear? That must be that one. Therefore, the defense did not violate the non-dissemination order by asking 7 of the 9 questions. Now, here's the remaining 2. And we pretty much already know what these 2 probably are, because the whole eye-opening for most people, not for us, we kind of all, not for us, I say not for us, we're I'm everybody. For me and for several of you out there, this was not eye-opening information. I was shocked it came out of the state's mouth. Okay? I was shocked this came out of the prosecutor's face. That's why I was befumbled, okay? I sort of already figured that was the case. I wasn't seeing proof from anyone, be it legal or family member of victim, okay, or PI or anyone on social media claiming to be doing anything with the family. I had yet to see actual factual proof. After all this time, the public has not seen actual factual proof. I kind of figured already. So I'm just going to assume that the social media question and the stalking question are these 2 questions. Okay. As to the remaining 2 questions, prior to the hearings, there was not information contained in the public record about these media items. However, these questions have now been read into the public record. Well, let me backtrack. That's not true. Because just like I said, they don't come out and specifically say, we think Bryan Kohberger was stalking Kaylee Goncalves on her Instagram in the PCA. All right. They don't come out and directly say, we think Bryan Kohberger was stalking Maddie Mogen because he was over there in the area per cell tower 12 different times. Okay. It doesn't specifically say that. Okay. There are terms used, verbiage used, sentences put together, insinuations made based off of the things that are public record that those questions were created from. And if he doesn't put that in here, I will be quite shocked and surprised, because common sense, duh, that's where the questions came from. It came from everything that's out there that people have used their brains to think about. If the exhibit says, oh, well, we have from phone records that he was over there 12 times in 2 or 3 months, and you want us to think that he was stalking somebody because you want there to be a connection so bad. Yeah, I'm looking at you, Banfeld and Grace and Coffin Daffer, all right? Y'all want there to be a connection that you can prove and say, I told you so. You want that so bad. You're sick for it. They're not giving it to you because it doesn't exist. It doesn't exist. But they have pulled you, being they, your Coffin Daffers and your Graces and your Banfields, all right? They have been out here pushing that insanity based off that verbiage. Okay? So even though they're allowing the survey, I really wish that the judge had the common sense to realize that. Because there's nothing wrong with those 2 questions, being as they are 2 things that aren't true. We got to find that out now. And maybe in the long run, Ann Taylor was kind of hoping this would nudge the state to maybe open their mouths and eat their own feet. You know what I mean? Stick their foot in their mouth. You know the term I'm looking for. Maybe that's what she thought was going to happen here, because maybe she just didn't think that the state was going to approve, and that the state was going to throw a fit, and the state was going to fight them, and the state was going to be upset, and Bill was going to blow up and talk. Maybe. Who knows? Let's continue. However, these questions have now been read into the public record and discussed at length during the hearings, including the facts that these media items may not be true. There is no may not, honey bunny. Y'all have specifically stated that they are not. Are nizot. Not may not, are not. Don't backtrack now, sweetie. You're stuck. You are stuck. We've got you already. It's in the record. Because the information is now in the public record, the court does not see any benefit in preventing the defense from continuing its surveys or requiring that the two questions at issue be eliminated. Again, these questions and media items are now part of the public record, and the non dissemination order does not prohibit the attorneys involved in the case or their agents from making extrajudicial statements about information contained in the public record. The non dissemination order also allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. One sec, hold on. Let my brain soak that statement in for a second because I want to say something, but I want it to be correct. Give me a minute. The non-dissemination order also allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial blah, 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 blah. So does that mean Ann Taylor has had the right to come out here and calm this bullshit down since the beginning? Because now I'm about to get upset. I'm going to read this one more time. Okay? The gag order allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from undue prejudicial effects of recent publicity not initiated by themselves or their client. So all this crazy shit that Coffindaffer and Grace and Banfeld and all these other people, because there's so many to freaking name, okay, on YouTube, on TikTok, on mainstream, whether they be ex-FBI, current, whatever the hell, all these people, okay? You're telling me that Ann Taylor could have come out and made a statement regarding this publicity that has been going on about the case and about Bryan Kohberger that was not initiated by her nor him. She could have actually come out and done something. I just need to move forward. I might be wrong on that, but I want to know what you guys are thinking about this. Am I not understanding this correctly? Because that makes it seriously sound as if certain statements are made and they're false and the client needs to be protected from these false statements, the lawyer has every right to come out and make extrajudicial statements, even though there's a gag order. Okay, yeah, we're going to move on because I'm a little aggravated. I need to make sure I'm thinking about that right. Okay. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. Man. Okay. Defense counsel argued at length that the two media items not contained in the public record were the subject of extensive media coverage that was prejudicial to defendant, and that the survey questions asking potential jurors if they had read, seen, or heard these media items was necessary to support defendant's motion for change of venue, which is aimed at mitigating the effects of prejudicial pretrial publicity on defendant's right to a fair trial. The goal of a non-dissemination order is to ensure a fair and impartial jury can be impaneled so that defendant receives a fair trial. If defense counsel believes asking these survey questions, which arguably contain prejudicial information or misinformation about defendant, is more beneficial than harmful, as defendant's expert testified, this court does not, at this juncture, have sufficient information or evidence to second guess that strategic decision by trial counsel. Oh. So let's go back to the statement that has me all confuzzled, right? Basically, they have the right to come out and be like, this is being said about my client and it's not the truth. Okay, bye, right? This survey is basically to prove the effects of all of those bad statements, false statements, things against Bryan Kohberger that have been said without Ann Taylor coming out and really having to say anything. this sort of like does it for her, I guess. I guess. But in the end, I guess because of that, and this is how my brain is taking it, okay? I'm not a lawyer. I'm just a person with a little bit of a brain who's trying to come out here and make this stuff make sense to everybody. Okay, I'm just trying my best. All right. At the end of the day, she is his attorney, and if this is what she feels and he feels is the best thing for them to do at this point in time, the judge technically cannot be like, oh, well, I'm not allowing you to do this, because then he's not being properly represented the way that his constitutional rights say that he has to be, right? So for the judge to be like, you can't do this anymore, then that's terms for appeals and all kind of stuff afterwards. It's sort of the same thing when it came to like expert witnesses taking the stand whenever we had, Larkin and all them, and the judge was like, well, in this one case, this one judge didn't allow the expert and it caused all kind of problems. We're just going to go ahead and do it. It seems like Judge really just kind of likes to put like plugs in things. Like he likes to kind of like, it's he's not very good at making a decision when he needs to make a decision. He tries to make both sides decently happy, but still like keep control somehow. But he doesn't do it in a way that like makes him take control, if that makes any sense. Like he doesn't seem like he controls the room the way that he should. That's the really only way that I can put that. And it finishes up stating, the court's order prohibiting contact with prospective jurors until further order of court is lifted, and the defense may continue its survey without modification to the survey questions. Any extrajudicial statements by any attorneys involved in this case or their agents must continue to comply with the gag order. Okay. And there's nothing. No. Now, the only other thing that we have here is that they're going to be having the change of venue hearing on June 27th at 10 a.m. And it will be in person, open to the public, and live streamed on the court's YouTube channel. So, you see what I mean? We had 2 hearings, all these motions filed, all these documents filed, all of these billable hours, all of this taxpayer money. And for what? The rest of the other 2 counties probably would have been done by now if none of this would have happened. All of this was put to a halt over a month ago. Actually, a month ago today, if you just do it by like calendar days, like date days and not actual whatever, you know how most people are. Our calendar is dumb. Anyway, this all got filed on March 22nd. Today is April 22nd. A month. Okay? A month. In that month, all of this could have been done. The other 2 counties could have been surveyed already. We could have had the results. We could have literally probably already had the change of venue thing coming up like this week. And now it's not going to be until next month. No, next month is May. It's not going to be until June, 2 months from now. So while I agree, like, this was stupid, I still like the fact it happened because look at the information we got. Look at the information we got, because we're seeing, this is like a huge experiment, I'm telling you. We're seeing the families not acknowledging facts that are coming out. We're seeing the mainstream media not acknowledging facts that are coming out, all because they're a complete 180 from the narrative that we have been being fed by them, and that they've all been feeding each other this entire time. They're acting like none of this exists. This was nothing. This was stopped because the state just didn't like the fact that they were doing something that the state wasn't aware of. The state's the one who got the calls. See, that's what the real problem was here. The state is the one that the county people like ratted to. The state and the police are the ones that the residents of Latell County tattletaled to. That's why the state ended up throwing such a hissy fit and acting like he had to go tell the teacher. Because look, in the end, like Judge was really only upset about the fact that Ann Taylor said that Judge violated Bryan Kohberger's due process rights. He wasn't even mad about the survey. He even said himself he expected one. Okay? All of this was for nothing. This is literally just a big old pee-pee measuring contest. Stupid. Dumb, but I want to know what you guys think. If you like the way that I present this information and give my opinion, please do not forget to leave a like on your way out and subscribe to the channel if you have not subscribed already. Just wow. See y'all.